Been waiting, many of you, since 8:30 this morning. We're closing in on 2 hours. Again, the court very much appreciates the patience that you're showing, and we just need to still wait for your attorneys until they check in. If you haven't already checked in with the deputy, make sure that you're checked in so that we know that you're here. Do we have anything else in queue?
We do have some bench warrants, judges.
Okay, why don't we go ahead and call those?
State of Wisconsin versus Michael J. Irvin, 13 CT 1025 and 14 CT 459. Both are operating after revocation. Attorney Jamie Semple-Weimer was present in court, but the defendant has not checked in. Appearance?
Dean, you will be at the state.
And the court notes that both of these cases were scheduled this morning for bail review at 8:30. However, the defendant posted the cash bail in each of the two cases according to records on February 26th of 2014. It's now 10:20 in the morning, and while an attorney checked in on behalf of Mr. Irvin has not checked in at all with the court. The court also notes that the pretrial monitoring program submitted a report that he is in violation of his obligations with that program. And so in each of the cases, the court issues arrest warrants for Mr. Irvin. The warrants are issued forthwith, remand to the commissioner, and the cash bail in each of the cases is now forfeited, subject to appropriate notice from the clerk's office and any recompense determination that might be made at the close of the case.
The likelihood of you coming back to court, the likelihood that you're going to commit a new offense while this case is pending. And in our county, we have a risk assessment tool that gives me information about what risk you pose on those two factors. Now, I also can consider as part of that, public safety. So, that's why we ask about how many prior cases you have, how many, were you out on bail in this case? Did you ever fail to come back to court before? What are your ties to the community, job and residence? And do you have a drug problem? And so I want to know those things so that when I set bail, and more importantly than the amount of bail, are the conditions of release and the supervision conditions, so they're tied to you as an individual, and that's why we're doing the things we do.
I couldn't help but notice that you have a slight accent. Do you understand, is English your native language, or you understand English well enough? All right. So if there is something that you don't understand, are you willing to kind of raise your hand and say, hey, look, I didn't understand that? Is that yes? Okay. All right, thank you, sir.
Attorney Mitchell, what is the status of the case? We're scheduled for projected plea and sentencing. Is there a resolution today?
Judge, I did have a discussion with Mr. Barton. We've also discussed it outside the court, not just today. He was requesting a trial date. I know that the matter was scheduled for a plea today. However, that was out of a pretrial where I did not have a chance to review discovery with Mr. Barton. And
probably, as I told Mr. Barton that day, the projected plea date for today was to give you an opportunity to discuss the case with Attorney Mitchell so that if there was a resolution, it could be presented today, but if not, then today we can select your trial and final pretrial date. So we'll schedule a trial and final pretrial, and I will prepare a scheduling order for the attorneys.
April 17th at 10 a.m. for the final pretrial.
Yes, ma'am. Thank you.
Next court date, April 17th, 10 a.m., final pretrial. Jury trial scheduled for May 6th at 8:30, and I will have scheduling orders momentarily.
And Mr. Barton, the court is reminding you that while the case is still pending, the no contact order remains in effect. So you are to have absolutely no contact with Joseph Lloyd, absolutely no contact with Stephen Borthwick, B-O-R-T-H-W-I-C-K. Remember that the no contact order is a court order, meaning only the court could change the order, giving you legal permission to have contact either with Mr. Lloyd or Mr. Borthwick while the case is pending. No one else, not even Mr. Lloyd or Mr. Borthwick themselves, can change the order and give you legal permission to contact them while the case is pending. So make sure that you're following that order as well as the other terms and conditions of your release from custody while the case is pending. And I will see you again on April 17th at 10 o'clock for the final pretrial.
I said, so just so you understand how we're going to proceed this afternoon, I'm going to hear first from the district attorney because they have the burden of proof. They're the ones that brought these charges against you. So I'm going to have them tell me what they think I should do. If the victim is here, I'm going to let the victim speak to the court and tell me what they think. If there are any other witnesses here that the district attorney wants me to hear from on restitution or something, we'll hear from them. Then I'm going to hear from your lawyer, who's going to tell me what the lawyer thinks I should do. If you have any witnesses here that you want to speak on your behalf, I'll hear from them. And then I'm going to let you speak. And if you want to speak in a different order when it becomes the defense turn, that's fine with me. But I'll give you an absolute opportunity to tell me whatever you want to tell me as to what you think I should do. And after I hear from everybody that's here on this case that wants to tell me something, then I'll tell you what my decision is, and I'll tell you the things that I have to consider at sentencing.
I think this is a serious incident. A child got hurt. You seem to recognize that, and that's good. And in all honesty, I appreciate that you feel bad about what happened, and I believe you're sincere in that. This is inexcusable behavior, Ms. Wright, and you need to be mindful that, you know, your children and other children in the community look up to you, and they shouldn't see adults whom they look to for guidance behaving this way. And whether or not there was a history here, whether or not he's a bad bus driver, all those things might be true, but you needed to deal with it in a more adult-like fashion. And if you need help with anger management, I can't really tell as I sit here if that's the case, partly because I'm not, you know, trained in that, but also I can't tell whether or not this is something that, you know, hurts you on a daily basis, but I encourage you to get it. You know, I don't know if there are anxiety issues in your life or stress issues that contributed to this, but getting mad and losing control is not the solution for you, and it's not the solution for this community. So I'll follow the plea negotiations here, but I think for your own benefit, Ms. Wright, and for your family's benefit, you might want to consider what you need to do in the long term to make you a happy person so that this doesn't happen again. And if that means counseling, if that means therapy, you know, those would be good things for you and your family. So I'll certainly encourage that, but I will this morning follow the plea negotiations, and I'm going to do that for several reasons. One is that you don't have a prior record. Two is that you appear very remorseful as you sit here this morning. So under those circumstances, I think it's appropriate to follow the negotiations. 7 days in jail is a long time, especially for somebody who hasn't been there before. And I think under the circumstances, the facts here are, you know, commensurate with that. So I will impose the 7 days. I am not going to impose a fine here. I take into account that you're not employed at this time, and you're, I believe, supporting, how many children is it? 2 children. However, there will be fees, costs, and assessments that come that I can't waive, that the legislature has made mandatory here, and they're substantial. It'd be a couple $100, I think. Do you need time to pay that? Further from you, Attorney Lamke?
2 things, 9 days credit on the imposing state time,
That'll be granted.
and possibility of expungement upon successful completion of all conditions of probation, including paying for restitution.
Mr. Zaromski, your attorney is asking here that this conviction be expunged from your record, and I have some concerns about that. And the law requires here that I essentially look at two things, whether or not it's in the community's interest and whether or not it benefits you. Well, it's always going to benefit you to have an expungement. So the harder question is whether or not it's in the community's interest.
All right, good afternoon, ladies and gentlemen, and welcome to Branch 2. I'm Judge Joe Donald, and we're about to begin the process of jury selection. I know there's a lot of you in here. We're going to select 13 of you to be the jury in this case. At this time, I'm going to introduce the attorneys and read off some of the names of the potential witnesses in this matter. The process that we're about to undertake is called voir dire. It means to speak the truth. It consists of the court asking you questions, and then the lawyers will have opportunities to ask questions. These questions are not intended to pry into your personal affairs or background, but we will cover some of that so that we can assess your qualifications to serve as a juror in this case. Ultimately, we're trying to arrive at whether or not you can be fair and impartial. All right, at this time, ladies and gentlemen, I'm going to have you answer some questions. The questions are as follows. If you could cross, if you do me a favor and just open up that panel for me. The questions consist of you stating your name, tell us whether you are married or single, tell us the number of children you have and their ages, tell us which part of town you live in, for example, north side, west side, or suburban. Tell us your occupation and that of your spouse. Tell us whether or not you've ever served on a prior jury, and if so, whether or not it was a criminal case or a civil case, and whether or not you reached a verdict, and if you did, whether or not you were the foreperson. And I know that that is a lot to remember, so that's why we have this little sign up here. We were able to find a little money in the budget, so we made a little sign. And so if you lose your spot, just look up at this sign and you can just pick up. I will also prompt you if you miss something, but that's the process. We'll begin with juror number 1. We have a microphone, and I want you to speak into the microphone because we have a court reporter who has to take down everything that's being said.